There's an estimated $30 billion sitting out there in unclaimed benefits and assistance programs that older adults and working families could be receiving right now. That number has been cited by major senior advocacy groups, and the reason it exists is not because people don't deserve the help. It's because the system is built with friction, forms, fine print, long phone waits, confusing eligibility rules, and a lot of people who assume they don't qualify without ever checking. Meanwhile, people with money don't leave benefits on the table. They have professionals who know exactly what to ask for and how to claim it. Most regular families don't. So today I want to do something practical. Walk through the most common Social Security-related benefits that people miss, and explain the exact misunderstandings that stop people from claiming what they're entitled to. This is general information, not legal advice, and rules can depend on your exact facts. But if any of these categories sound like you, it's worth taking the next step and getting a proper benefit check. Let's start with one of the biggest missed money categories, spousal benefits. If you are currently married, spousal benefits can apply when your own Social Security retirement benefit is relatively low compared to your spouse's. The basic idea is that the lower earning spouse may be able to receive an additional amount based on the higher earning spouse's record. Here's where many people get confused. They compare the wrong numbers. Social Security doesn't just compare what your checks are today. The key comparison is usually based on your full retirement age benefit, often called the primary insurance amount, or PIA, not simply the reduced amount you're receiving if you claimed early. So if you look at your current monthly check and your spouse's current monthly check and think, mine isn't less than half of theirs, so I must not qualify, you might be wrong, because you may be comparing reduced checks instead of the full benefit amounts. Also, under current rules, when you file for retirement benefits, Social Security generally treats you as applying for any spousal benefit you're eligible for at the same time. This is often called deemed filing in the background. The old file and suspend strategies that people used years ago have mostly been eliminated for new situations, and that's another reason people rely on outdated advice. A common real-world scenario looks like this. The lower-earning spouse claims their own benefit first, then later, when the higher earner starts their benefit, the spouse benefit can be added if eligibility is met. Now let's talk about divorced spouse benefits, because this is another massive unclaimed money bucket. If you are divorced, you may be eligible for benefits on an ex-spouse's record if you meet key rules. The big one most people know is the 10-year marriage requirement, and unfortunately, it's strict. In most cases, if you were married 9 years and 11 months, Social Security will treat it as not eligible for divorced spouse benefits. That's why people who are close to the 10-year mark should never guess, get the exact dates right. One weird but real exception people don't know: if you divorced the same person and then remarried that same person later, Social Security may be able to count the two marriage periods together in certain situations. It's not common, but it's real. Now here's a belief that blocks people from applying. My divorce decree says I can't claim benefits on my ex. Social Security does not care what private divorce paperwork says about Social Security benefits. A divorce decree can divide property, address alimony, set custody rules, but it typically cannot override federal Social Security eligibility rules. Social Security is going to look at the legal facts, marriage dates and divorce dates, and whether the requirements are met. Another belief that blocks people: my ex has to be receiving Social Security first. Sometimes yes, sometimes no, depending on the type of divorced spouse claim. There is a version often referred to as an independently entitled divorced spouse benefit. The idea is simple. If you've been divorced for at least 2 years and both you and your ex are at least 62, you may be able to claim a divorced spouse benefit even if your ex has not started collecting yet. This matters in real life because people get stuck in permission thinking. They assume they need their ex to file first. They don't want to call the ex. They don't want conflict. Or the ex is refusing to start benefits out of spite. In the independently entitled situation, the ex does not have to be collecting for you to be eligible, if the rules are met. Also, people worry, if I claim on my ex's record, will it reduce their check or affect their current spouse? For divorced spouse benefits, your claim generally does not reduce your ex's benefits. It's not taken out of their payment. Many people never apply because they don't want to hurt someone else financially. In most cases, it doesn't work that way. Now let's address common law marriage because people get completely blocked here just because they don't have a standard marriage certificate. Social Security has rules for common law marriage, but the tricky part is that marriage law is determined by the state, and states differ. Some states recognize common law marriage, some used to and no longer do, and some never recognized it at all. Social Security follows the state's legal recognition and will require whatever proof that state requires. So the best move, if you believe you had a valid common law marriage, is not to panic and not to assume you're automatically denied. You file the claim, and Social Security will tell you what evidence is required for your specific state and time period. Sometimes that evidence includes affidavits, joint financial records, shared address documents, insurance, tax filings, or other proof of holding yourselves out as married. Now let's move into survivor benefits because people leave money on the table here constantly, especially people who had multiple marriages. Survivor benefits are different from divorced spouse benefits. The 10-year marriage requirement is mainly for divorced spouse benefits. Survivor benefits generally can start as early as age 60 and earlier in some disability situations, and the marriage duration requirement is usually 9 months in many cases, with some limited exceptions. Also, the benefit amount can be much larger than people expect. Survivor benefits can be up to 100% of the deceased spouse's benefit, depending on the age you claim and other factors. Important detail: survivor benefits have their own full retirement age schedule, and it isn't always identical to your full retirement age. That's why survivor claiming decisions can be strategic. Some people take survivor benefits first, then switch to their own later if their own benefit grows and becomes higher, or vice versa. People often never recheck eligibility years later, even though circumstances and benefit amounts change. And here's a situation many people miss. If you were married more than once and a former spouse is deceased, you might be eligible on that deceased spouse's record, depending on your current marital status and the rules for that type of survivor claim. Social Security can compare options and determine which benefit is highest, but you have to ask and verify. There's also a special survivor category that matters: disabled widow benefits. In certain cases, if you are disabled and within a certain age range, commonly discussed as 50 to 59, you may qualify for survivor benefits under disability rules. The timing and disability onset requirements matter, so this is one where you should get a precise review. Now let's talk about child benefits because this is an enormous missed money area, especially for families deciding when to claim retirement. If a parent is receiving Social Security retirement benefits, disability benefits, or is deceased, children may be eligible for benefits on that parent's record if the child is under 18 or still in high school, often up to around 19 and 2 months, or disabled with disability starting before age 22. This is often referred to as disabled adult child benefit. Here's the big mistake people make. A parent delays retirement benefits to maximize their own check, not realizing that by delaying, they may be giving up years of potential benefits for minor children. Sometimes the best decision changes completely once you factor in child benefits, because that can mean multiple checks per month for years. On top of that, there is a spouse benefit connected to children called child in care benefits. If one spouse is receiving Social Security and there is a child on the record, the other spouse may be able to receive benefits if they have a child in care who is under 16 or disabled. Disability began before age 22. This is commonly missed because families get told no at one moment, maybe because of earnings limits or family maximum rules or timing, and they never revisit it. But situations change. Someone stops working, earnings drop, children age into or out of categories, or family maximum math changes. Speaking of earnings limits, if you take certain benefits before full retirement age and you are still working, Social Security applies earnings rules that can temporarily reduce checks if you exceed the annual limit. The number changes each year. People forget about this, get overpaid, then receive a repayment notice later. That's not necessarily Social Security messing up. It often starts with unreported or unpredictable earnings. Now, a quick word about grandparents raising grandchildren, because this comes up constantly. A grandchild may qualify on a grandparent's record only in specific circumstances. Commonly, both parents must be deceased or disabled, and the grandparent must meet support and living arrangement requirements, or the grandparent may have legally adopted the child. The details matter, and it's not automatic. Now let's talk about SSI and disability for children, because families often don't apply due to misinformation. SSI, Supplemental Security Income, is a needs-based program for people with low income/resources, including disabled children in some situations. One reason SSI matters is that it can connect to Medicaid eligibility in many states. People assume they won't qualify and never file. Sometimes they're right, but sometimes they're wrong, and they lose years of support because they never asked. Now let's move into disabled adult child DAC benefits, which can be life-changing and is one of the most misunderstood programs. If someone became disabled before age 22 and meets the disability definition, they may be able to receive benefits on a parent's record once that parent is retired, disabled, or deceased. People assume, I'm 35 or 45 now, it's too late. Not necessarily. The issue is proof that disability began before 22, which can be challenging but not always impossible. Medical records, school records, old evaluations, and other evidence can help. Also, marriage rules matter for DAC benefits. In general, marrying someone who is not also in the DAC category can end eligibility, while some specific exceptions may apply in limited situations. This is another reason people should never guess. Finally, there's a benefit almost nobody knows exists: parents' benefits. If an adult child dies and the parent was dependent on that child for at least half of their support, the parent may qualify for benefits on the child's record in certain situations. It's not common, but when it applies, it can keep someone housed and stable. So what should you do with all of this? If you think you might qualify for any of these categories, the most important step is not arguing with yourself or assuming, I probably don't qualify. The most important step is to get a benefit review using correct numbers and correct rules. 3 practical moves that help immediately. 1. Don't compare current checks to guess eligibility. Ask for the full benefit amounts used for calculations, because that's where many people misjudge. 2. If you were told no years ago, recheck. Laws, benefit amounts, marital status, work status, and eligibility categories change. 3. If you're divorced, don't assume your ex's behavior controls your options. If you're eligible under independently entitled rules, you may not need the ex to be collecting. The truth is, a large portion of unclaimed money exists because people never asked the right question in the right way.